Good evening. This 2013 meeting of the Police Oversight Commission is now called to order. Okay, so now we move to 236-12. Mr. Paul Hernandez comes to appeal his letter. Mr. Hernandez, are you here? Mr. Hernandez, you have 15 minutes to make your case.
Sir, if I may request that you pause the time so I can pass out some exhibits.
That is, you may.
And then also, if I may, I wanted to present a video as well, so I want to just plug in the laptop as well on that time.
Is there someone who can help him do that? Do you know how to do that?
I could do it at a break, or if you wanted to pass me over, I could work on it, if you would like. May I approach?
You may distribute your documents. I'm not going to spend the commission's time waiting for you to connect a video, unless someone overrules me and tells me I should. Is there anyone who would make a motion to allow him the time to connect his video?
What video is it?
I don't know what video it is.
The video of the incident.
Mr. Chair?
Yes.
I would move that we review the video of the incident. I wanted to do that at this hearing anyway.
The lapel camera from the officers will be played during the IRO and the APD's portion of our...
Thank you. Then I withdraw the motion.
Is that the same video you have? Is that the same video you have?
It likely is going to be the exact same video. However, I would like to use it in my presentation and thus be able to control the video.
Okay, if somebody can help him connect that, if you could bring those forward.
No, I already have it. He wants his own, though.
What is it? What am I supposed to do? Oh, and pass it? Is this new material? Mr. Chair, this is new material. Under the rule, I think there is a provision for new evidence, but I don't know that anybody's looked at this in terms of...
I believe that the chair would have to admit it as new evidence, and it's not been provided previously. And
Yep. Okay, so I've been advised by counsel if you could address the microphone, Mr. Hernandez, and tell us what this evidence is. Generally, not point by point. And then, Ms. Hammer, you will have a chance to respond.
Okay, marked as Exhibit A and Exhibit B are transcripts from the video itself, from the incident itself.
I would submit that I certainly haven't had a chance to look at the transcript and compare it to the video. Mr. Hernandez was given notice of this hearing, and he certainly made no effort to communicate with the opposing side that any new evidence would be submitted.
No, I would submit that this is not new evidence. It is a record, and the video is on record. They plan on using the video.
We're more than willing to play the video, but certainly any transcript would be new evidence.
Okay.
Mr. Chair?
Commissioner Barella, do you have something?
I just have a question. You said it was a transcript. Was it certified by, or who transcribed it? Was it certified by?
It was by my legal counsel. They subcontracted out. I cannot provide the exact author.
So there's nobody that at the end certifies this is a true and correct copy of it?
It is not certified to my knowledge. However, I did not produce the document. It was produced by an attorney.
Mr. Chair?
Commissioner Shine?
I assume you are not an attorney, sir?
No, sir.
But you are represented by counsel in this matter?
No, sir.
Oh, I thought, I'm misunderstood. I thought you said this transcript was prepared by your counsel.
It was prepared by my counsel in a separate matter.
Okay.
Okay. I'm going to rule that because we have no way to verify that it is a true and accurate transcript of the video, that we cannot accept this evidence. But if you can get your video connected, or if you're willing to wait,
Well,
let us see it.
Okay. I would make a motion then that they continue my hearing till a future date. I was provided fairly short notice. I could provide a date for you if you'd like. It's approximately 7 days. With the holidays and work, it's extremely difficult to put this stuff together. The IRO has had over 1.5 years to prepare for this, and I would ask for an extension. Also, if I could be provided any rules related to the entry of exhibits in this hearing.
Okay.
Mr. Chair?
Yes, Commissioner Shine.
I would like to, at this time, make a motion to continue this matter until January. Would that be? To the January hearing?
That would be fine if I could.
And the reason I do that is because this gentleman is not a lawyer, and there's no question the niceties of legal practices. If you got a transcript, you give it to your opposing counsel in advance so they can check it out and all that. But you can't expect that this gentleman who's not a lawyer knows those niceties. So I would make this motion to continue it till January, with the understanding that it'll give the transcript to the IRO, and they can review the transcript and by January agree that it's either accurate or inaccurate. Because from my point of view, the transcript would be very helpful, because generally, especially in this room, it's very hard to understand these videos.
Is there a second?
If I may.
Commissioner Barella, excuse me, sir. Commissioner Barella seconded the motion. Is there discussion? Commissioner Siegel?
Thank you. I believe that Mr. Hernandez said he had several pieces of evidence he wanted to introduce. He may as well let us know what those several pieces are, and those should all be considered as possible pieces of evidence that we would hear. I would ask the chair's indulgence to let him continue to describe what else he would like to show us for evidence.
Okay. You have a transcript, you have a video, do you have other?
Correct. The second item is a supplement narrative. It's an unofficial copy of the police report, simply highlighted to make a point. It's actually documents that you already have reviewed, likely. However, mine is an unofficial copy. I'm not sure if you have an official copy or unofficial, but it'll be documents that you actually already have in your possession.
Is that it?
No, I have a few more. Exhibit C is sections of sworn testimony provided by Officer B under oath.
Okay.
And those are transcriptions as well.
What else?
And lastly, email chain between myself and the investigator in this involved in this case.
One of the IRO investigators?
Correct.
Okay. Okay. Is that it?
I believe so.
Okay. Ms. Hammer, would you respond to the legality under the, is there anything about the union rules or anything else that would prevent these documents from being introduced or our continuing this?
Well, under the rules, an appellant can move for up to 2 months to have their case continued to another hearing. The rules do require it in writing, but I'm sure that the chair can to make a amendment to that rule if it's approved by the commission.
Okay.
As far as the other documents, I would just request the opportunity to review those between now and I believe it's January the 11th is the next hearing, and that any positions that I would have with respect to the evidence, make it at that time, and we hear what the commission and the chair can rule on the positions of the new evidence, which would be new to the record.
Okay.
Mr. Chair,
Mr. Shine?
may I suggest that, in all fairness to Mr. Hernandez, who's not a lawyer, that if Ms. Hammer has any problems with any of the evidence, he give him a week or 2 weeks notice or something of that fact so that he can have time to prepare before the hearing.
Sure. I'll give him a week's notice prior to the hearing.
Okay, so the motion was to
Continue the matter.
continue, thank you, until January.
Chairman, if I may.
Yes.
And I did not realize the date was on the 11th. I actually have a personal holiday on that day. If I could actually then just
February?
if I could just push it to February docket, and then
Anybody know the date in February?
No, I will in a minute.
and then if I could.
Oh, I'm sorry, I was wrong. It's January the 9th is the day. It's a Thursday, the second Thursday of the month in 2014 would be January the 9th.
Does that make a difference for you?
That'll make a difference. I'll accept that date. If I could question to the board, is there a procedure that I can follow to have these exhibits qualified and entered, several weeks before the January 9th hearing? That way I am not, getting responses on several different exhibits from the IRO, then putting me in the same situation where they're claiming that they don't have an opportunity to respond or something to that effect. I'd like to qualify the exhibits prior to the 9th so that they're already in the record.
It seems perhaps that given the question and the concern, perhaps February would be a better time for this.
I would defer, but if the exhibits are provided to me today, I could get back to Mr. Hernandez by January the 2nd, which would be a week before the hearing, and he would have time. But ultimately, the decision whether or not the new evidence will be taken will be by the chair and the commission. So there's no way to do that ahead of time.
I suppose it was my understanding that we could come to an agreement that the records are accurate, and thus they wouldn't be challenged. In fact, I could step out or after the hearing or at a different time and date and sit down with the IRO. She can review the documents, and then possibly we can just make a joint motion to.
Well, whether they're accurate is one thing. Whether they are appropriate and admissible in this, under our rules in this procedure, that's a different thing. So just even if they're accurate, they may not be appropriate. So, but Ms. Hammer can help you with that. Can help you sort that out.
I understand. And is there a third party? I feel very strongly, and I'll present this to the commission when I have my time, but the process here is extremely biased. I was not really given an opportunity to provide a full statement and or evidence. The email chain will reflect that. So in essence, I feel very strongly that she's doing nothing more than preventing these exhibits from entering now, which the board could examine for accuracy when the video was presented.
Could we have our legal advisor look these over and make that determination?
Well, I think it's a call at which the commission must say whether or not the evidence will be taken in as new evidence. and
Okay.
that it'll be submitted to the chair at the next hearing.
Yes, help me out here.
Sure, Mr. Chair. Kevin Curran again, City Attorney's Office. My sense is that if the Mr. Hernandez and and Ms. Hammer can come to a stipulation on the evidence, then that stipulation can be considered by the commission at the next hearing. That seems to me to be the simplest way of getting the documents into evidence with the least amount of brain damage.
Okay. Yes, you may, Mr. Siegel.
Thank you, Mr. Chairman. If we were, as a commission, to offer our opinions to the chair as to whether one of those 4 packets ought to be admitted or not, it seems to me we should have read it first. If it were found by the commission to be inadmissible, we couldn't use it in our deliberations. But I don't know how I could imagine reading, there's a lot of paper up there on the podium. I don't know how we could read that on the fly during the hearing and be expected to understand it and make that kind of a judgment. So my request in lay terms, I'm not a lawyer either, would be to have that documentation distributed to us no later than the 2nd of January, along with the IRO's recommendations to us as to the admissibility or non-admissibility of them. And we can form our own opinions and come to the hearing ready to ask the questions we may need to ask and determine at that time how we feel we ought to proceed with respect to new evidence. Is that fair enough, Mr. Curran? Is that an okay way to proceed?
Mr. Chair and Commissioners, I apologize. I'm not that familiar with your rules to know if that's the appropriate way to proceed. My intuitive thinking is that the Commission should not be receiving evidence outside of the hearing process that's not already in the record.
Commissioner Foster, you have a request. Or
Mr. Hernandez, point of.
Yes, sir.
I'm on. Point of clarification. What you're saying is that these documents that you are wanting to present to us are actual transcripts gleaned from the cameras at the time of the arrest. Is that correct, sir?
Exhibit A and Exhibit B are what you're stating. They are transcripts taken directly from the incident, the audio and video of which the police department has. The Exhibit C actually is transcripts from sworn testimony provided by the officer involved in this case under oath.
Let's go back to the first 2 exhibits, Exhibit A and Exhibit B. So why you're, and I need this for my clarification. It is my impression is that you want to present this so that when the IRO shows us the tape, we have not only a visual accuracy of the information, but also a written accuracy of the information. Is that correct, sir?
That would be a large section of why I would like to. The other large reason would be that there's an extreme bias in the documents that have been provided to you and the investigation that has been conducted, and thus you truly have you don't have the facts to make an informed decision. And these exhibits are factually based off of the video and audio. They're undisputable.
So, but sir, what I'm saying is that what we are addressing is you're going to give that document to the IRO. The IRO in turn is, I'm assuming, going back and going to review the lapel camera for accuracy. If you and the IRO agree to that it is the lapel camera is accurate, then would we need to have that document in front of us?
I believe so. for a couple of reasons. First and foremost, the audio quality on the video itself is extremely poor. It's very difficult to grasp without watching repeatedly the video. I think it makes a very clear record of the incident. Also, it will assist the commission when the videos are played to follow the record.
But once again, Mr. Hernandez, the document is a reflection of the video. And if you and she concur that the video reflects the document, then we may not necessarily see that. The document C, the final one, you said this is a testimony of an officer under oath.
That's correct.
Under oath in relation to a
This incident.
a court proceeding?
An external proceeding, non-criminal.
And is this a transcript also, sir?
This is also a transcript.
By a certified transcriber?
Okay, we're
And
going
if I
to,
may make one record on the exhibit A,
okay, please.
the time constraints make it very difficult to fast forward and rewind a video. I'm limited on time, so the transcript allows me to jump specifically to sections of the record.
Okay. We have a motion before us as to whether continue the hearing, the citizen's complaint, and it's time to vote.
Mr. Chair,
It's time to vote.
may I make one suggestion to council before we vote?
Okay.
That is, if in fact the IRO and the Mr. Hernandez can stipulate to admissibility of this evidence on or about January 2nd, do you see any problem with our then getting the evidence in advance with a stipulation? Because presumably, if both sides are going to stipulate, we're going to accept the evidence.
Mr. Chair and Commissioners, the problem is with your rules. It says, as I'm rereading your rules now, the rules say that new evidence has to be accepted at the hearing. Okay.
Fine. Okay.
I appreciate your attempt to expedite things, but that was one of the reasons for my original suggestion of trying to have the party stipulate.
It's another example of the quality of our rules.
Okay.
Thank you.
Let's move to our vote. We have a motion on the floor to continue this hearing of the appeal till January the 9th. All in favor, please raise your right hand. It is unanimous. Let's move on.